I see Makita is here.
Good night.
Good night. We already said good night to you.
But I just come in.
Yeah, I know. I saw when you came up on the
Oh, I probably couldn't hear
chat.
it.
Yeah. I see Shakel just came on. Let's see. Leads. I think that's what everybody ate. 1, 2, 3, 4, 5, 6. I have 6. Maki, you had a chance to finish looking up the case, or are you doing it now?
I looking now. I just rejoined.
All that time?
Yeah.
Living on the wrong side of the island.
I guess I could just catch up.
No.
People go to it.
No, some people are still looking.
Okay.
Yeah, we wait to see if anybody else comes, and it's 6:06. So let's see if anybody else joins us, and then we'll start. It's like I said, the chapter is very short, but I want to go over pre-incorporation. Oh, I like this full site. Copy. Everybody was able to find the first one?
Yeah, I found the first one.
Okay, so we're gonna start first with Kellner. So see if you could find Kellner. And then we'll do Kellner, newborn, phonogram, and then Cotronic. So Monique, you will take the Kellner? You comfortable with that one? Monique.
Yes, ma'am. Yes, ma'am. Just give me a few minutes. I'm still writing.
No. I just saying I'll assign you Kellner.
Okay.
Okay. And Katina, you want to do newborn?
Okay.
Okay. And then Raven, you do phonogram?
That's fine.
Okay. Cameron, are you going to do Cotronic?
That's fine.
Oh boy, wonderful. All right. Tell me when you're ready. I know you're still looking up. I think everybody is on now who's normally on. So I'll just give you a couple more minutes. Yes.
Good evening.
Good evening.
My apologies for being late.
No, that's okay.
No, it's not, but okay. I appreciate you saying that.
No, because everybody's looking up their cases now.
Which cases?
Oh yeah, you late then. I sent an email.
Oh, well, I'm
Uh-huh.
sorry.
Yes, look at your email, you'll see. You'll see an email. Oh, wrong place. Okay, so that's that one, that one, that one. Let's delete. Okay. They're not difficult to find, right?
No, they
Okay.
Clearly, I did not check my email.
Well, it happens to the best of us.
I'm sorry.
That's okay.
It's been a trial 3 weeks on the stretch, so my brain is scrambled.
Yeah, so we'll wait for you. I think everybody is wrapping up their cases, so
Alrighty, let's see.
we're ready.
Of course.
Okay, Monique, you're up first.
okay. So Kellner versus, sorry?
Go ahead. I just was saying this, everybody know we're talking about pre-incorporation.
So Kellner versus Baxter. So the facts of the case is that a group of promoters for a new hotel company, Grace and Royal Alexander Hotel Company, entered into a contract for wine. Before the company became incorporated, so pre-incorporation, they went into contract for this wine. eventually, before the company was incorporated, before money had been paid out, all of the wine was consumed. The Gravenson went into liquidation, and therefore the promoters were sued because, of course, the wine had already been consumed. The promoters argued that the hotel chain would have been incorporated if they were not sued in the process of liquidation, sorry. And the promoters said that Gravenson had incorporated a contract, had subsequently been ratified if they were allowed to go full throttle before they liquidated. So the issue was were the agents liable for the pre-incorporation contract post-ratification by Grayson. So the court ruled that some of the quotes was, if Grayson Royal Alexander Hotel Company had been an existing company at this time, the persons who signed the agreement would have signed as agents of the company. But as there was no company in existence at the time, the agreement would be wholly inoperable unless it were held to be binding on the defendants personally. The cases referred to where a contract is signed by one who professes to be signing as an agent, but who has no principal existing at the time, and the contract would be altogether inoperable unless binding upon the person who signed it. So that was the extent of that case, where I don't see a judgment on what I'm looking at.
Mm-hmm. You mean like what was held by the court?
Yeah. I know the court was saying that because the company was not incorporated, of course, it was not into a contract.
Right.
And the persons, the agents,
So-
because the company was not incorporated, the agents were not contracted because of that as well. So.
Okay, so it was held by the court that because the company did not exist at the time of the signing of the agreement, it would be wholly inoperative unless it was binding on the promoters. It didn't exist. Second point, it says a stranger cannot, by subsequent ratification, yes, relieve the promoters from that responsibility of liability. Now, my question to Makita is, under Bahamian law, what the second point I just said that the court held, what would the courts in the Bahamas say?
Sorry, give me a second point again.
A stranger cannot, by subsequent ratification, relieve the promoters from that responsibility of liability. So if this was in the Bahamian court, would they rule on that second point?
If it was ratified?
Yes.
If it was ratified, then yeah. If it
Under
was
section, yes.
If, to my understanding, if it was ratified, then there would be they would be at fault because they ratified anything that would have been done by the promoter.
Right. Now, I want you to look at section 22, subsection 2, which is what you're using. And I want you to notice there's a key word in that subsection.
Section 22?
Section 22, subsection 2.
In the
You're right,
Companies?
Makita. Section 20, yeah, in the Companies Act. I want Celicia to tell me what is that keyword.
Oh, okay. I see.
What's that keyword? We're getting a lot of static here. That's also. Oh,
I I hearing it. I don't know where it's coming from.
I don't
I think
know.
it's coming from me. I'm gonna have to shut down. Give me a minute. I'm gonna have to come back in.
Okay, we wait for you. Yeah, it was her phone. Okay, Celicia. You can start speaking when Lisa gets back on.
No, that's Felicia what left.
That was her? Oh, I thought
Yeah,
that
she
was
said she
Lisa.
gotta come back.
Oh, okay, okay.
So you were saying read 22 section, subsection.
Two. The same one that you used for your answer. I want you to tell me what is the key word in that subsection.
Bound?
Mm-mm.
Just one word, right?
That's one word.
Adopt?
No,
Well, then I don't know. My only other word would have been intention.
that is the word.
Oh,
That is the word. That's the key word in that subsection.
because they would have intentions to do something based on whatever the promoter
Yes.
went into.
That is the key word, intention. Did they intend? So they can ratify it, but it all comes to whether or not that was the intention of the company itself to do that. And that's why when you actually act as a promoter, you have to be very careful. Because if you're relying on subsection 2, the company may not ratify it.
If it wasn't their intent. So you would have to draw up something
Yes.
for that.
If I go to Christina now, Christina, if you're not going to rely on subsection 2, what else can you do?
Now, Christina, trying. No, literally.
Yes. What you trying to do?
I trying like, yeah, come back to Christina.
I must come back to you.
Yes.
Oh Lord.
What was your question?
Yeah, because I right now trying to understand.
Okay, Makita, you said under subsection 2 of 22 that the board can ratify it. And I was pointing out to all of you is that the key word is intention. Was it their intention when they would have spoken to this promoter or the promoter went out doing whatever he had to do? Was it their intention that they would ratify it once the company is incorporated? If that intention is not there, they may decide not to ratify it. So my question to Christina is,
or they can keep it if they, I think you said they can keep it if they want. You mean the contract?
what else can that promoter do? Just don't forget now, once he engages as a promoter and enters in the contract, he is liable. So he's trying to protect himself. So you got to try to figure out whether or not, once it's incorporated, if it was their intent to ratify it, or what else can you do to protect yourself?
You could put in what you call it? It could, like you. Oh,
A clause.
For yourself, like stating. I know what I want to say, but I can't say it.
Well, okay, if you can't say what you have to say, then show me where it is in the act.
Call the police.
Did you mean call the police?
Would that be 3?
No,
Oh, hold
three
on.
speaks to after it has been adopted.
Okay. But one says, except as provided in this section, a person who enters a written contract of the name, in the name of or on behalf of the company before it is incorporated is personally bound by the contract and is entitled to the benefits of the contract.
Mhm.
So then in the contract, you would have to put a stipulation then.
Yes, and
So
that's
they'd
what
have to lose
Christina-
their benefits? Would that be something?
Yes, but I'm waiting for Christina to tell me. She said it, but she needs to tell me where it is. Christina,
I'm here. Like I have it in my head, but I can't. Like
go to section 22, subsection 5.
shut up, Devin. What's that?
You see it, Makita?
Yeah.
So yes, you would insert a clause, but you need to make sure it says this. That you as a promoter will not be bound by the contract and that you're not entitled to any benefits of the contract.
So therefore, if you, so it's a risk then.
It is a risk, that's why it's a liability.
So if you are bound to it, you could reap the reward.
Yes.
But if you're not, and something good comes out, you can't get the benefit. But if something bad comes out, you don't get the liability either.
Correct.
So it's a gamble.
It's a gamble. Now there's another alternative that you can have. What's that alternative, Cameron?
I'm not too quite sure. I'm not sure.
You're not sure? Okay, let me go to Lisa.
No.
Lisa, what's the alternative?
I didn't hear the question.
Okay, you can go as a promoter and be exposed to all of the liability with the hopes that the company has had the intention when you started out promoting that they will ratify it. You could protect yourself by inserting a clause to say that you're not to be bound by the contract and you're not going to get any benefits from the contract. Then Makita brought in the point that, okay, so you'll have no liability and you don't have any benefits. But what if you want to have some of the benefits?
Then you insert that in the contract. You insert those terms in the contract that anything done in furtherance of the contract, you would get a certain percentage of.
Exactly. Or you can go to the court.
As in, so you apply to
And
the
enforce
court for different obligations.
Yes. An apportionment of the liability and of the benefits. Or like Lisa said, you can insert it in the contract. So let's go to the next one. So Kellner is what they call is very strict.
That's what it calls, strict?
It's very strict, yeah. The decision by the court was very, very strict.
Okay.
So even if they have intentions to gain profits, okay, never mind. Mm-hmm.
You sure?
Yes, Archie, I have a question. Okay,
Go
if
ahead.
you have, before you incorporate a company and you have a contract with the promoter to get, I guess, some stake in the company.
Now stop right there. Stop right there. Stop right there now. You have start again.
If you have, okay, it's a promoter and
Mm-hmm.
they want to, you drum up a contract and they want to have, I guess, some shares within the company. When is it a
Mhm.
different contract? Like after you incorporate the company, does that contract prior to being incorporated, is it different? Or does that contract still hold up?
It goes back, sorry,
Go ahead. It goes back to the intention.
right.
That key word. Remember I told you that's that key word.
It goes back
When-
to the intentions of the parties, and then if it is that the intention, then it's ratified after incorporation.
Okay.
Right. So 22 subsection 2 governs everything. After that, when a promoter is out there, it has to be what is the intention.
Okay.
And remember now, the intention is not talking about the intention of the individuals, the 5 people you're talking to or the 3 people who want to incorporate it. It then becomes to the intention of the company. Because remember now, once the company is formed, it is a legal entity. And the decisions made would be the decisions and what's in the best interest of the company.
Right.
So if it's not incorporated as yet, whoever much persons that are going to own the company can ratify this on behalf of the company?
No, the company itself does it.
Yeah, but I mean, the company as a body of what, if it's not in existing yet?
Yeah, so all the persons will say, okay, once the company is formed, we're going to ratify this. So there was an intention.
So you'd have to do that for each contract you're gonna basically go into with.
Yes, because each
Different
one is gonna have to be approved by the company.
Okay.
So Kellner is restrictive in nature and it will only be applied on its terms. That is, where a purpose purport or person purports to act as an agent for a non-existent company.
Say that again, please.
Where a person purports to act as an agent for a non-existent company.
Okay.
That's Kellner versus Baxter. So now let's go to Katina.
Yeah,
Newborn.
newborn versus solid. Okay, is a written contract purported to sell goods by a company described as Leopold Newborn London Limited. The document was described by the name of the company, but it was signed by Mr. Leopold Newborn. And the company wasn't incorporated yet. So the contract was in the company's name, but signed by the promoter. So it seemed as if the company who's doing business with them didn't want to, they were deceived because they thought the company wasn't ready in existence and they didn't want to proceed with the contract, it seems. So Lord Godard, he said in his opinion, unfortunately, though it may be as the company was not in existence when the contract was signed and there never was contracted. And so the contract didn't go through and they didn't enforce the contract because, of course, it was the name of the company that was getting the goods signed by the agent or the promoter. And I guess that would refer, when you refer to the Companies Act, the capacity of powers on 24. And I was trying to read that to see if I know it was something in there about limited liability and not limited liability, about limitations. Because it seemed as if he led the seller or the buyer, the company that he's buying from, that the company was already in business.
And it wasn't.
And it wasn't right. But I'm trying to find the exact one.
He made a contract for a company which did not exist.
Right. Right, so number 25, contract made according to this section on behalf of a company, but otherwise invalid. You know, if not otherwise invalid. But I was also wondering if it was fraudulent, as like a criminal and different than company law, because it seems as if he knowingly misled the vendor that he was thinking that he was selling to a company and not a person.
They just did it purely under contract law. I mean, because you can't say it was misrepresentation.
Okay. Well, yeah. Well, yeah, it was a misrepresentation because the name on the contract should have been Mr. Leopold.
Yeah.
Mr. Newborn, instead, right? And it wasn't.
See, they say that what his name is, Mr. Leopold.
Mhm.
Leopold never purported to contract the contract to sell, nor did he nor sold the goods either as principal or agent. He never used those two terms.
Mm.
He contracted and purported to be made by the company. He never put himself out there.
Okay.
And he said he signed it as a future director. And so in that case, the contract was a nullity.
Yeah.
Yeah, you're supposed to be a future director of a non-existent company. So the contract is null. Everybody understand newborn?
Yeah, I understand.
Yes.
Okay. So go to Raven, phonogram.
Phonogram, a collateral contract was entered into with the company which had not then been incorporated, under which an advance by Phonogram to support an intended new pop group was payable by the company if a recording contract was not entered into within 1 month. The collateral contract was signed for and on behalf of the company by which Mr. Lane. Both parties knew at the time the collateral contract of the company had not yet been incorporated. Court expressly rejected the argument that Section 9 should be construed solely by the reference to the directive. Section 9(2) is in accordance with the spirit and intent of the directive. We should go on by our own statute and not the directive. This is the first time the section has come before us. It will have much impact on the common law. It will have much, yeah. I am afraid that before 1972, the common law had adopted some fine distinctions. As I understand, Kellner versus Baxter decided that if a person contracted on behalf of a company which was non-existent, he himself would be liable on the contract, just as if a man signs a contract for and on behalf of his horses, he is personally liable. But since the case was decided, a number of distinctions have been introduced by Hallman versus Pullen.
Did you look that one up?
This was a summary, but I didn't look up these cases that they had here.
We just did newborn.
Yeah.
Who didn't have a case? Someone could do Black versus Smallwood out of Australia.
That wasn't in the email, I don't think.
No, I said someone could look it up now who didn't have a case.
Oh,
We'll do that one last. So everybody understand phonogram. The rock group intended to perform under the name Cheap, Mean, and Nasty, and to form a company for the purpose to be called Fragile Management Limited. So Mr. Lane accepted a check from Phonogram for £6,000, signing his name in quotes for and on behalf of Fragile Management Limited, end quote. The money was to be used to finance production of an album and was repayable if this was not achieved. When the album was not produced, Phonogram sought to recover the money from Lane. The company having not been in existence at the time the contract was made, Lane argued that his signature for and behalf of the company amounted to an agreement that he was not to be personally liable on it. An agreement to the contrary in terms of Section 36 of the Companies Act. And the court held this was not sufficient to exclude the operation of the section, which would be given full effect unless there was a clear and express exclusion of personal liability. Lane was thus liable to repay the money. So again, in this one, you see the court is saying it's the same as 22 subsection 5. unless there is a clear and expressed exclusion of personal liability of the promoter, he will be liable.
Because he put for and on behalf of?
The company did not exist.
That's what I said, because he put those words though, for and on behalf of.
Mm-hmm.
And then the intent, I guess, was to perform under the cheap and, what, mean and nasty?
The group intended to perform under the name Cheap, Mean, and Nasty and to form a company for the purpose to be called Fragile Management Limited.
Okay.
And so he signed for on behalf of Fragile Management Limited, which was not in existence.
So you take up everything for them then there. Just or is it because just how he got the benefits of getting the money, he got to take the liability too, because
the company did not
nothing.
exist.
Okay.
It didn't exist.
What case did you say to look up?
Small versus Blackwood. Black versus Smallwood. Opposite way. Black versus Smallwood. Okay, Cameron, can you do Catronic?
Yes, ma'am.
Okay.
The case of Catronic versus Designate.
Yeah.
Designate signed the contract leading to some building work at a residential home, signing for and on behalf of his company, Wendeland Builders Limited. Unknown to him, the company had been struck off the register about 5 years earlier. On learning this, Designate registered a new company with the same name and sought to rely on S36C to claim the benefit of the contract. And it goes on to say it was held that
that section didn't apply.
Say it again.
Section 36C did not apply.
Right, yes, ma'am.
Mm-hmm.
And it's held a contract entered into prior to the incorporation of company to which that company was ostensibly a party was void unless the company entered into a fresh contract to the same effect after the incorporation.
Mm-hmm. Okay, everybody understood that one?
No, can you summarize that for me, please?
Okay, so the facts is just as simple as Cameron said. Designate signed a contract to do some building work at a home. And he signed for on behalf of his company called Wendeland Builders Limited.
Mm-hmm.
But that company had been struck off the register 5 years earlier. Unknown to him. I don't know why it's unknown to him. He's using a company name and didn't check to see if he was compliant.
Uh-huh.
So on learning this, he registered a new company using the same name. And then he sought to rely on the section in the act to claim the benefit of the contract. And the court held that that section did not apply.
Because it's a new company now?
This was not a case where a contract had been entered into on behalf of a company not yet formed, but on behalf of a company which had not been formed many years before. The contract was struck off for almost 5 years.
So he was trying to say the company that he just formed was the company that was in the contract, which didn't exist.
Yes.
Until, let's say, 5 years ago.
Uh-huh.
Okay.
He couldn't do it. All right, I have some questions for you all. You see how funny and nice this is? Let's do the last one. You looked that one up, Makita? Black versus Smallwood.
I'm looking at it now. From what it's in a summary.
Okay. As you can see, sometimes the summary themselves don't give you much.
No, I don't know.
You don't see it?
I see it, but it's not. Okay, hold on. All right, I have to read this out then. It's saying the High Court upheld the decision of the full court of New South Wales, which had reversed the decision of Jacobs J in the High Court following the decision of a court of appeal in the Newborn versus Censulae, held that the defendants had contracted not as agents, but as directors, and that therefore they were not personally liable. However, all members of the High Court expressed the view that when a man purports to contract as agent for a non-existent principal, the question as to whether or not he is personally liable on the contract depends on the presumed intention of the parties in each case.
Stop
And
right there. You see that word? You see that word again?
Intention, presumed
yes.
intention.
Mm-hmm.
And denied that Kellner versus Baxter is authority for the proposition that there is a rule of law that when a man purports to contract as agent for a non-existing principal, he is personally liable to the contract, on the contract. With respect to the High Court, it is submitted that it is precisely this proposition which was laid down by the court in the common plea of Kellner versus Baxter. It says, the cases referred to in the course of the argument fully bear out the proposition that where a contract is signed by one who professes to sign as agent, in quotes, but who has no principal existing at the time, and the contract would be altogether inoperative unless binding upon the person who signed it, he is bound thereby. And then it goes to a reference.
Mm-hmm. Go ahead.
I think that's.
And then they went back on to Kellner and then go to the bottom. As the decision of the High Court in Black versus Smallwood was based on the fact. Go ahead.
The defendants contracted not as agents but as directors. The observations of the court on the effect of Kellner versus Baxter are strictly speaking obiter dicta.
Because we're talking about two different roles now. We're talking about agents and then you're talking about directors.
Okay. However, they represent the considered opinions of all the members of the High Court and will undoubtedly be followed. It would appear, therefore, that on this matter, the law in Australia differs from the law in England. So I don't understand what happened then. Okay, see where it says the principle laid down by Kellner and Baxter is that if a person contracts ostensibly as agent for non-existent principal, he can be held to be himself personally liable. It is a plain that the principal that the agent is personally liable.
In this case, what the Australian court is saying is that they did not follow Kellner and Baxter. They say Kellner and Baxter is based on the principle when someone acts as an agent of a principal for a non-existing company. Mm-hmm. They're saying in this instance that the persons when they sign as not as agents, but they sign as directors, and therefore they were not personally liable. But then the question comes back, how can you be a director if the company is not formed?
Yeah. So what was the end result for that?
The directors were not personally liable.
Because they stand as directors. So if they're agents, they would have been personally liable.
Yes. Let's see if we can find another summary of that case.
Yeah, that summary isn't too long.
New genius. What's the name?
Anybody find it? Black versus Smallwood.
Do you have the citation?
1965, 117, CLR 52, Australia.
So the company was informed when.
That's what we're trying to find out right now.
All right, so it's.
Black v. Smallwood. No. What's going on with this?
Informed them.
It's an Australian case. Let me see if I have it in my book. So even though Australia is a Commonwealth jurisdiction, they have a different, let's see, what did I say it's called?
No, I can't find it. Let me try.
You can't find it, eh?
Osley.org.
I'm trying to see if I could find it. No, I don't have it either.
Let me try.
Let's see if I could find a link.
I see a reference tag, but
Yeah, we've seen references, so we need to find the actual thing. I don't have it. Let me see. Kellner, newborn. Okay, I have one. Let me see. Okay, listen to this. The High Court of Australia took the same rule of construction approach in this case. Black and others had contracted to sell land to Western Suburbs Holding Party Limited, which was signed by the defendants, Smallwood and Cooper. Western Suburbs Holding Party Limited was not incorporated at the time, and Smallwood and Cooper signed as directors, thinking the company had been incorporated and that they were directors. The plaintiffs wanted to impose liability on the basis of a rule of law reading of Kellner and Baxter, saying that a contract was clearly intended, and since it could not be with the principal, that is the company, which was not in existence, it must have been with the purported agents Smallwood and Cooper personally. The majority of the court followed the earlier English case of Newborn and Censulae. It was held that Kellner versus Baxter was not authority for the principal, that an agent signing for a non-existent principal is bound. The court said that the basis of the decision in Kellner was the inference that the defendant promoters were bound by the contract according to the nature of the contract itself. In this case, it appeared to be clear that a contract with the company was intended. The company did not exist, and thus it was a contract with a non-existent party, and therefore no contract at all. It was nonetheless suggested that the defendants could be liable for a breach of warranty of authority. In the case
how
of...
could they mistakenly think that the company
I don't
was?
know. I don't know how they could mistakenly think so.
Mm,
I don't understand the mistakenly part. Hold on, let me see. They went on talking with somebody else. Let me see. He says here, they cite another case in the middle here. They say the common law position created a risk for both the promoter and the third party that there would be no enforceable contract. Black versus Smallwood and Wickberg versus Shatsky involved cases in which the third party could not enforce the contract against the company. Newborn versus Censulae involved a situation in which neither the promoter nor the company could enforce the purported contract. This creates a risk that reliance on the purported contract will be defeated, along with the potential for an unjust enrichment of promoters at the expense of third parties, or third parties at the expense of promoters. For instance, had the court not found the promoters liable in Kellner and Baxter, Kellner would have borne the entire loss on the wines that he supplied for the hotel company, rather than having that loss shared amongst all the promoters. A similar problem could arise if promoters performed the purported contract but could not enforce the contract against the third party. The common law position, he said the common law position also creates unnecessary costs. So to say here the conclusion, Jesus, this conclusion is long.
Yes, it is.
This is very long. I trying to see what was the end result. Let me see. The court takes effect. Okay, for me. Oh, you see what he says here, Makita? You found this version? What we have?
no.
Wait,
what's that on
type in law teacher, put a plus, and put small versus. Let me see what the heading of this is. Put in law teacher plus. Everybody can put it in. Whether the promoter can be personally liable. law teacher, plus whether the promoter can be personally liable. It should come up.
One of it's the first one.
Found it?
No, hold on.
What do you mean no? Yes.
Not
No?
law teacher, plus
Yes.
whether the promoter can be personally liable.
Uh-huh. It's not coming up?
All I get is lawteacher.net.
That's it.
Oh.
That's the website. It's
Or
coming
then you
up?
have to search, then you have to search it in nothing.
No, once I put it in, I got it. Hold on, let me send it to copy. Here. Anybody else found it?
I found it, but this is long.
There's
Yeah, it's very long.
often promoters of
I
companies.
need to
That's
find,
what it says.
I need to find something shorter.
Swamp.
Oh, come on. Move from here. I need to find a shorter one. Because I don't have it. Okay. All right. So let's see if we can find a shorter one. I mean, that is a good one, but it's too long. And normally you can find these Australian cases very easily.
I'm going to send a link. I found the case, but I'm going to send the link. I think it's too long too.
I found the actual case.
Me too.
You found it? Okay, so let's see what he said at the end. Oh my God, this is long.
Right then. I sent a hyperlink. You should be able to link it.
Okay.
I found something, but it's saying High Court of Australia.
Yes.
Yeah.
Oh, okay, probably the same thing then.
Warwick, CJ, Keto, Taylor, Windale, and Owen justices.
Yeah.
Yeah, that's it.
Yeah. Okay. I'm going to the end. Everybody has it?
Yeah, I still can use this link in case it's something.
Yeah, the one that I sent you is a good one. The law teacher.
You won't send it in the group though right now.
No. I have to send it to everybody. I thought it was the law teacher. I can send it to everyone afterwards. Okay, so shut up cost oxidation. Okay, this is on an implied warranty. We said appeal was dismissed. Go back to the beginning.
I still don't get, I don't even believe it was.
Yeah, I remember reading the thing again. How could you believe?
Yeah. I mean, I don't know if they signed consent to be directors without actually looking at the incorporation certificates.
That don't make no sense. They're saying the case in Newborn is exactly on point. Yeah, it's just similar to Newborn. I see why. Because remember, I told you in the summary for Newborn, it said that the contract purported to be made by the company on whose behalf it was signed by a future director. So they are actually not directors. They are future directors.
That's something that don't exist.
Right. And as much as the company was non-existent at the material time, the contract was a nullity. So
Oh, okay, now I see.
now you see, right?
Yeah, now I see, and there's something the weather the promoter can be.
Mm-hmm.
Okay.
So he relied on the case of newborn and Censulae.
Oh my God, I must find my company law notes.
Huh?
I said I must find my old company law notes.
You think you have that case? I don't remember this one, small and Blackwood now.
I will find my manual.
Okay.
I've read Newborn Decent Solid. I'm sure.
Yeah. It is one this nigga.
Settle land whilst it was still only in the process of.
Read the paragraph 3.
The argument?
Yeah, the argument of the appellants was put in 2 ways. Because I think the appellants lost.
Yes.
They lost. So in 3 is saying the first argument was they entered on behalf of a company to be formed, and this involved them in a personal obligation to fulfill the terms. Okay. Okay. But they're still arguing that these so-called future directors were acting on behalf of a principal, but the principal was non-existent.
Mm-hmm. So they weren't held accountable.
I think they were.
I see what say that,
Because it says at 8, these reasons lead us to the respectable conclusion, not only that we should follow the decision in Newborn, but also that the decision in that case was correct. So they were liable.
I see where it say to, it had been displaced by the 2 cases referred to, but it was asserted that it was displaced only in cases where a person had purported to act on behalf of another existing person whose authority he lacked.
Read paragraph 8. He remembered the decision in Newborn. And he said he was sorry to say that the contract could not be held up. They dismissed the appeal.
From the people who were suing.
Mm-hmm. We can come back to that one. I want to take a while, but I think that's what they follow. Because you have another judge then going on. By then, you should find a shorter version. Let me see what it says for black and small and black. Because in phonogram, it said, since that case was decided, a number of distinctions have been introduced by Newborn and Censulae or Censulae and Black versus Smallwood.
I'm gonna paste this,
Right. So who did phonogram again? They read phonogram. Who did phonogram?
That was the second one?
That was Raven. Is she having supper? It says, those 3 cases seem to suggest that there is a distinction to be drawn according to the way in which an agent signs a contract.
Which number this is you reading?
This is phonogram, when they refer to Black versus Smallwood.
Oh, okay.
That's why I was asking Raven to read it. But she's not listening. Cameron, do you have it? Or Linda?
No, ma'am. I'll have to look it up.
You don't have that one, eh?
No, ma'am.
You mean the
Let
exact
me
one,
see
what
that.
you're talking about?
The exact one that she read.
Oh, no, I don't know the exact one that she read.
I think I have those exact one that she was reading from.
Okay, read the distinction that they made with those 3 cases.
That'll be with paragraph 3. That distinction was disliked by Windire in Black versus Smallwood. It has been criticized by Professor Friedel. In my opinion, the distinction had been obliterated by Section 9, subsection 2 of the European Communities Act 1972. We now have our own clear words where contract reports to be made by a company or by a person as an agent for a company at a time when the company has not been formed. That applies whatever formula is adopted. The person who purports to contract for the company is personally liable.
Okay, so in the phonogram, this is what he said. This is what the judge said. Lord Denning. You know, Lord Denning always goes off on a different tangent from everybody else. He says, referring to Holman and Pullman, Newborn and Censulae, and Black versus Smallwood. He said, those three cases seem to suggest that there is a distinction to be drawn according to the way in which an agent signs a contract. If he signs as, quote, agent for X company, end quote, quote, for and on behalf of X company, end quote, and there is no such body as X company, then he himself can be sued upon it. On the other hand, if he signs it as X company per pro himself, the managing director, then the position may be different because he is not contracting personally as an agent. It is the company which is contracting. And then it says that distinction was disliked by the judge in Black versus Smallwood. And so they says that with the European Communities Act, it says that distinction has been obliterated with whether or not it's agent for on behalf and all of that. It says we now have clear words. Where a contract purports to be made by a company or by a person as agent for a company at a time when the company had not been formed, that applies whatever formula is adopted. The person who purports to contract for the company is personally liable.
So all this came after these cases then?
Yes, yes. And the judge said these distinctions would have been made prior to the European Communities Act. In a case where a contract is either with a company or with an agent of a company. So all of that has been done away. So the only way you could get around all of this is exactly what our law states. You either put a clause in it saying that you're not getting no benefit, you're not liable, or you put a clause in it which says what your benefits are and what your liability will be. Or you just take the chance that based on the intentions of the parties to whom you're going to be entering in the contract on behalf of, that once the company is incorporated, that they will ratify it. So everybody should get full points on that mandatory question on pre-incorporation. Agreed?
What's the mandatory question?
It's on pre-incorporation.
Uh-huh.
It's on pre-incorporation. I will give you a scenario and you will have to decide.
You want to give us a practice scenario?
That listen, yeah. You know how much work it is to write one?
No, I mean, you might just know something, another thing about your hair already, like another case, without us having to look up, without giving us the name of the case, just, substitute names.
On Sunday. How that sounds?
Okay.
I hear one, okay. What with the rest?
Yeah.
Okay.
We'll
So
see.
now you know that section 22 is very important, right?
Yeah.
Yeah.
So there's when you answer this question in the homework, don't just write down section 22. Okay, got to know what it is in his own words. In your words. Let's go to unit 5. So unit 5 speaks about corporate record keeping. And you know that in any business, whether you're operating your own business or you're working for someone, you have to keep records and you have to keep good records. And depends on the role that you're in, you have responsibility for certain documents. So when it comes to keeping a company records, there's reason why you have to keep it. One, to ensure the limited liability protection for limited liability companies, which means that all of your documentation has to be on record and it has to be up to date. You have to ensure that filings are done at the correct time. ensure that payments are being done at the correct time and that you have the receipts. So that means that you have to ensure that statutory, legal, and regulatory compliance is done. So when I say statutory compliance, what documents you think I'm looking for?
Memorandum and stuff, no?
Memorandum and articles.
Statutory
If I say
document.
legal, what documents are you looking for?
The statement? I don't know. Sorry.
Statement? When you say statement, what do you mean? Financial?
No, I said annual statement.
Annual statement, yes. And if I
Definitely
say regulatory, what we looking for?
regulatory.
Operation.
Due diligence.
That's one, yes, due diligence.
Directive.
Due diligence, what else could be regulatory?
Anything that is required by statute or rules.
Yes. So you can see that they can overlap, correct?
Yeah.
Okay. The third thing is to allow the shareholders to be able to inspect corporate documents properly and adequately, which means that once you receive a document, you should file it. Document the shareholders, the directors, and officers of a company and their due diligence information, which means that the KYC on these persons should always be up to date. And to represent current and accurate information on the company is corporate and financial affairs and shareholding. So the register of members, the register of directors and officers have to be current, and also the financial statements you have to make sure that the audit is done and is completed within time. So for a company under the Companies Act, there are certain things that should be in your books ready. First one, you know you're required by law to have a registered office at all times. The address has to be filed with the memo and arts. You have to have the address of the directors. You need to know that the registered office, if it changes its address, you have to notify the Registrar General. You have to have the copy of the memo and arts, all amendments, minutes of the meeting, resolutions, copies of any notice, any register that is required by the legislation, which is the members and directors and officers. They have to be kept. Make sure you have the addresses. And when someone leaves, what should you put in the right column? If someone leaves, retired or resigned.
Or deceased.
Or deceased, yes.
And the date.
And the date, yes. And it's always best to do them as the event occurs.
And the date should be the same as on the, if there's a new resolution coming out to appoint or remove.
Exactly. All the dates must tie in because you're gonna have the resignation letter, or you're gonna have copy or evidence where the person was deceased. And then you need to tie that into the appointment and the resolution, and make sure that you do it within the time frame that's in the memo and arts. So we know we have to do the statement, we know we have to do returns. And of course, the name has to be published at the registered office. So if it's an IBC, we know they have a registered office in the Bahamas. They must have the address. Submit that to the Registrar General. Any change, again, has to be advised. The person who's acting as a registered agent must be licensed by the Securities Commission under the Financial Corporate Service and Providers Act or under the Banks and Trust Companies Regulations Act. Their address should be also given to the Registrar General. And of course, you have to maintain a share register. Register of mortgages and charges. Register of directors and officers. And it also has to be filed with the registrar. And of course, you should be able to inspect the company records by a member or by an attorney. Need to put to you. I'm gonna go around the room by the list that's on my phone. Lisa,
Sorry,
I said I'm going to ask some questions and I'm going to go based on the list that's on my phone. How does that sound? You're first. Your name is up first.
let's see what I know.
Okay, let's see what you know. If you don't know, it moves to Makita.
Oh, great.
And she's next on the phone. What do you mean, oh great?
I'm excited.
Oh my Lord. Hold on, I wrote my notes. I'm looking for it.
Just on what you just gone over.
This is everything that we've learned so far. This is not. What happened? Why do you all get so pirate?
It's not like you're digging far. I need to go like all the way back to the first class or something.
No. I wrote some notes on a piece of paper. And I'm trying to find it. What you mean? Go back to the first class. Everything starts with the first class.
It's like you're digging far. Like,
Everything starts with the first class. But I just can't find my sheet of paper. Hold on.
that might be the Lord.
I can't. No, it is not. That's the devil. That's the devil getting in my way. And I had my things marked and ready for you all.
Sorry, Ms. Archer, I'm gonna have to leave. I just got some word. We had a death in our family, so I'm gonna have to
Oh
leave.
Lord, have the deepest sympathy.
Okay, thank you.
Yes. Okay, we'll talk to you next week. Oh, these people dying like crazy. This is not good.
Not,
Every time you turn around,
Yeah.
someone is passing away. It's not that page. Why is my things disappearing?
Maybe you thought you wrote it down.
Oh, no. Don't try that.
Real.
No,
Sometimes
it was
dreams
not.
feel real.
Really? So you say. No, not that. Not that. Not that. Past that. No, not that. Not that. Let me see now. Not that. Where did my thing go, man? I had my questions line off. That's not it. Don't worry, I'm gonna find it.
Devil busy, man. He busy.
Don't worry about that. I will get this.
I say it's the devil that might just be God saying
What?
something. You know, you find out stuff afterwards, you know.
Yes.
You mightn't understand it in the time.
Mm-hmm. But I'll understand it later, age.
By and by.
Okay. Who can propose a written resolution? Thought I couldn't find it. I have it. Who can propose a written resolution?
any director, shareholder, member of the company.
Do they have to have a certain voting right percentage?
It depends on the memo and act, right? I mean, it depends.
What does the Companies Act say on voting rights?
I think voting rights are equal to your share, the amount of shares you have.
Okay, so section 71. You're supposed to have your little Companies Act just handy. No, that's a different number. I forget this thing of a different number from the real number. I don't like this consolidated thing.
71 says extraordinary general meeting.
No, I don't want that.
It says, unless the articles otherwise provide, voting at a meeting of members shall be by a show of hands, except when a poll is demanded by a member of an or an appointed proxy holder entitled to vote at the meeting.
Okay. What does the schedule at the back say? Or schedule? So it says on a show of hands, every member present in person shall have one vote. On a poll, every member shall have one vote for each share of which he is the holder.
If you have 10 shares, you have 10 votes.
That's what it says under Reg 59, under the first schedule.
So that applies to who writing the resolution? Who
But-
authorizing the resolution?
So don't forget now, once the resolution, if you're going to say that the members resolved whatever it is, contract, whatever it is, you have to know exactly how much votes you need in order to carry it. So written resolutions provide an alternative to formal meetings for decision making.
Okay. So if
And
we
of
have like
course-
4 of us, if we have 4 of us, if 4 of us inside it and you need, let's say 80, I have 50, someone have 10, someone have 20, and someone have 30. So me and the person who have 30, if we sign that, then that goes.
Unless the memo now says something different.
But that's only with members, right? So what about with directors? That depends on the memo and action.
If they have voting rights.
If they have voting rights. And normally it's just one, they just raise hands, they disagree. So you have to look at, you have to see what the article says. And if the article is silent, then you go to the act. And when you go to the act, to the section that was just read, and it just states what it is, then you have to go to the first schedule unless the articles actually stipulate in detail how much voting powers you have. So what are the essentials of a meeting?
Or the essentials of a meeting?
Need a quorum, the quorum.
What's the section? I have mine, I'm looking in mine. I don't like this.
The meeting of the members?
What, a meeting?
Yeah.
Seven says unless the articles otherwise provide, a quorum of members shall be present at a meeting of members at the holders of a majority of the shareholders entitled to vote at the meeting are present or person or represented by proxy. You want me to read it? Go on?
77, you said?
Yeah.
17. It has 3
Go ahead.
subsections.
Go
Subsection
ahead.
says, if a quorum is present at the opening of a meeting of members, those so present may, unless the articles otherwise provide, proceed with the business of the meeting, notwithstanding that a quorum is not present throughout the meeting. 3, if a quorum is not present within 30 minutes of the time appointed for the meeting of members, the meeting stands adjourned to the same day, 2 weeks thereafter, at the same time and place. And if at the adjourned meeting, a quorum is not present within 30 minutes of the appointed time, the members present constitute a quorum.
That's section 70 or 777.
70.
So let me ask you a question. What if there's only one member?
A member would constitute the quorum.
Yes. Everybody has that?
You can repeat that, please?
Yeah, okay. I asked the question, what if there's only one member? How do you form a quorum?
Just that one member would be the quorum, right?
Yes.
So the member declares that it's the quorum, and they can have the meeting with themselves, or they could just write down what they want to have.
Just write down whatever they want to say. Yes, correct.
Yeah, I rather right now. I don't want to be talking.
Oh, Lord. So if I were to ask you, what makes a person qualified as a member to be at a meeting? When you say it's a qualifying person, what does that mean?
They would have to be a shareholder.
Uh-huh.
Proxy.
A proxy. Now, when you say shareholder, you mean a person, right?
Correct.
Okay, so it's a person, it could be a proxy, or it could be a company.
As a shareholder.
Uh-huh.
Yeah, an entity.
So you're saying, okay, what makes a person qualified to
A
be at a meeting?
qualifying, yes, qualifying person. It either be an actual person, it could be by proxy, appointed by proxy, or it could be an actual corporate representative. Is it essential for all the members to be in the same physical location for a meeting?
No.
No.
Everybody say no. Where's it in the act?
Place of meeting.
Mm-hmm.
68.
And how many meetings should they have? The members.
Meetings the members of a company shall be held at such place as is provided by the articles, or in the absence of any such provision at a location within the Bahamas as the directors determine. The member who attends a meeting of the members held outside of the Bahamas agrees to its being so held unless he attends the meeting for the express purpose of objecting to a transaction of any business on the grounds that the meeting is nor lawfully held.
Okay, did you say how many meetings they should have?
No. Yeah.
You didn't write?
No.
Okay, so where you gonna find that answer? You have to go to the first schedule. 45. And it tells you a general meeting shall be held once every year. And it tells you when you should have it.
So that's the annual general meeting, and the board of the directors meeting is twice a year then.
The board of directors meeting is, let's go back to the act. That's the general board meeting, notice and waiver. Directors meeting on my own, it says 92. Unless the articles otherwise provide, meetings of directors of a company may be held within or outside. Upon such notice, a majority of the numbers or minimum number of directors required. Nope, it doesn't say.
Which section is this you're looking at now?
I'm looking at 92, 93.
That's the companies are.
Yeah, you in the IBC?
No, and the companies. I don't have it in paper, so I have to be.
Oh, you're scrolling.
'92 and '93.
I was in 90s.
92 is removal of director.
Yeah, you forget yours is not the same as the rest of us.
What's your side in gold and black, the note?
In 93?
Yeah, what it mean, what the section name?
Oh, it says delegation. But that's not what it says on the index.
93?
Yeah, that's what mine says.
Oh, mine says notice of waiver.
Yeah, I'm telling you, everybody has a different document.
So this wouldn't be under the same thing as the meeting.
But for the members, no, it's a different section.
It's after that?
Mm-hmm.
Let's see, notice of directors.
No, it doesn't seem to say. And the thing on how many.
Oh, okay, I've noticed already.
No, I'm reading the. It's saying the directors may meet together for the dispatch of business, adjourn, or otherwise regulate the meeting as they think fit.
But for the AG, the annual general meeting?
No, for the directors.
that's
Someone asked about the
okay.
board of directors.
Yeah, I did. I
Yeah.
remember seeing it in the chapter in the book. I'm trying to remember which chapter. I think it was in the first chapter. I know it
Yeah.
mentioned twice for
That one that
twice
you
for
read,
directors.
but
Yeah.
that's on the side.
On page 44 in our text.
No,
talk
I mean,
about the directors.
she say as they see
Oh, what?
fit.
You mean the one I just read?
Yeah, what does say on the side of it?
That's in Reg 83 from the first schedule. Remember, I told you all 2 classes back to make sure you print the first schedule at the back of the Companies Act because it gives you details. So the proceedings of directors. It says the director may meet together for the dispatch of the business, adjourn, or otherwise regulate their meetings as they think fit. So you could have 2 meetings a year, you could have 4, you could have 6, some people have 12, some people have 24.
Well, when it's necessary then.
Whenever it's necessary. Questions arising at any meeting shall be decided by a majority of votes. In case of an equality of votes, the chairman shall have a second or casting vote. So always remember that. The chairman can have 2 votes. A director may, and the secretary on the requisition of a director shall at any time summon a meeting of the directors. So it's not just the chairman, it's a director can ask for meeting to be held. The quorum necessary for the transaction of the business of the directors may be fixed by the directors, and unless so fixed shall, when the number of directors exceeds 3, be 3. The continuing directors may act notwithstanding any vacancy in their body. But if and so long as their number is reduced below the number fixed by or pursuant to the regs of the company as the necessary quorum of directors, the continuing directors may act for the purpose of increasing the number of directors to that number or of summoning a general meeting of the company, but for no other purpose. So if one of the directors resigns or dies and they don't have sufficient numbers, then they can ask for the general meeting to be for a director to be appointed. They can elect a chairman at their meetings and determine the period for which he is to hold office. But if no such chairman is elected, or if at any meeting the chairman is not present within 5 minutes after the time appointing for holding the same, the directors present may choose one of their number to be the chairman of the meeting. Did you know that?
So they could choose any director during the meeting to be the chairman.
Yes, if the chairman is not there. Within 5 minutes of the time appointed for holding the same. The directors may delegate any of their powers to committees consisting of such members or members of their body as they think fit. So for those who work in a regulated entity, you would see that there's always at the back of the guidelines a list of committees that a bank or a trust or security or insurance company can have. And on those committees is normally a representative of the board, one of the directors. And say any committee so formed shall in the exercise of the powers so delegated conform to any regs that may be imposed on them by the directors. A committee may elect a chairman of their meetings, and if no such chairman is elected, or if at any meeting the chairman is not present within 5 minutes for holding the meeting, the members can choose another person at the meeting to chair it. The committee may meet and adjourn as they think proper.
Question.
So the meeting, so go ahead.
Where they could choose, oh, you said one of their member to be a chairman. So if you're not a director, you cannot be a chairman.
Get cut off.
If you are not a director, can you still be a chairman
Of a committee?
for the meeting?
You say if you're not a director.
Mhm.
No, you have to be a director.
In order to be the chairman of the meeting.
Yes. Uh-huh.
That make me think about something.
Like what?
I can go back and look at that right tomorrow. I think
Because it says, see, notice what it says. It says at 86, the directors
I think
elect the chairman of their meetings. But if no such chairman is elected, the chairman is not present within 5 minutes, the directors present may choose. The directors.
The chairman was not listed as a director. That's what made me ask that question just now. I can look at that tomorrow.
So what do you mean the chairman was not listed as a director? So what do you mean?
He wasn't listed as a director. He's a director now, but I'm looking at some past minutes. He was chairman, but I didn't see him listed as a director.
But he has to be a director to be the chairman. He has to be a member of the board of directors.
Exactly. The
That's
chairman is just saying he's the role to head the meetings and chair the meeting like a job.
But that's what
He
I
has
said.
to be he has to be a director.
In their registered directors, at that time, he was not listed as a director.
So,
Something.
so how did he act?
I don't think I go look at that tomorrow because I don't know what kind of thing was going on there.
I don't understand.
I think you would do a class on shadow directors. I met Ms. Archie, she may have to do a class on shadow directors.
That's in here. We come to that later. As what was his role in the company?
He could sign in the capacity as a member on behalf of a company. This is a complex company, so it's like.
What you mean?
Okay, so let's just say it's a company, right? And this company is owned by 2 other companies.
Okay.
So he can sign on behalf of one of those companies as shareholder, I guess, or member.
Mm-hmm.
Yeah, that's it.
And so he sits on this board.
He's a director now, but all
but at that time, he sat on the board as chairman of this company that was owned by these two companies, one of which he was a member.
Signing for one of the companies. It was a company that was transferred in, so that's why I was looking at the old minutes.
But what did he
and I
do?
just-
But what did he do at the meetings?
It said
Because he was
chairman.
not a director, so he didn't have votes. What did he do? Who voted?
It was saying the other directors.
Okay,
So I guess he just was
just carrying out the task of being chairman,
organizing her, yeah.
organizing the meeting.
Yeah, probably. You know, some people just be doing what they want to do, so.
Yeah, but there's a right way and there's a wrong way.
Mhm.
If you have a board of directors, when should they retire?
Individually,
End of the what?
being individually retire,
Yeah, when should they retire?
yes, when they're no longer of sound mind.
Because I know there's some sit on boards in the 80s.
Yeah, if you want
So
a
they don't
sound
want to
mind.
retire. So they don't want to retire at 65 like everybody else.
No, they don't.
Oh, okay, that's good.
So what is the correct answer for that?
It depends if you have an internal policy which stipulates that either they retire because of unsound mind or you stipulate an age. Or you could have it whereby, as according to Reg 75, the directors to retire in every year should be those who have been longest in office since their last election.
That's only if they retire every year.
Right. You could do it every 10 years. Normally what you do is you do a what they call a skills review. So you look at the end of each year to see whether or not the directors have the skills that you're looking for to run the company and to take directed to take it into the direction that the shareholders want the company to go. And you also look to see what contributions that they have made during the year. So if they're not making any contributions, then you need to retire them.
Is that a vote?
So
No.
who makes that decision? Other directors or?
The chairman would make that, would say that to the members, to the shareholders, that they're not going to be re-elected.
What if they had like 10 meetings and they contributed to like 3 of the meetings, then that could be cause to go?
It depends if the other 7 meetings were not in matters that are under their expertise. Remember now, each director who's appointed to a board is appointed for their expertise. So it depends on the type of company or the purpose for the company. That's how directors are supposed to be selected. Each one contribute to their area of expertise. So you have everybody who has the same expertise, then the company is not going to go anywhere. And retirement is based on whoever was the last one, whoever's the oldest one there. And remember that the shareholders can increase or reduce the number of directors. And they could determine the rotation cycle if it's not already stipulated in the articles. So sometimes it'd be very careful if you select someone to the board who's already near to retirement. So we still, don't forget that we're not talking about 65. We have some people who they keep on the board who are in their 80s or in their late 70s, and they keep it for historical reasons and continuity, as long as they're of sound mind.
What did you say before continuity?
But that would mean, in terms of keeping the person there, I'm saying that for continuity, they keep sometimes the older persons for historical reasons and continuity. So there's always someone who's sitting on the board who knows the history of the organization. Of course, the articles could give the directors the power to add new directors or to appoint. Whose responsibility is it to ensure that financial statements are prepared?
Directors.
Yes. And how many times during the year are they obligated by statute to present financials?
One thing.
Once a year. So that'll be Reg 102 in the first schedule. And it actually states that that should include a balance sheet. So you're getting the hang of this. My exam question could come from anywhere.
Yes, that's.
Getting excited here.
Huh?
I said you're getting excited.
Yeah, of course. What's the role of the chairman? Since Makita asked that question, but the chairman, I just thought, let me ask, what's the role of the chairman?
That is a good question.
Organize, like to
What does that
organize the
mean?
meetings. That's what. Mm.
I don't like that
Chair
word.
the meetings.
What does that mean? Using the same word.
So that means
Chairman
that
is to chair the
they
meeting.
will
Appointed by
bring
the board
the
of
meeting
directors.
to order, talk about what they're gonna talk about, discuss first.
Uh-huh.
And when they make decisions and they do their voting, then they say, okay, call to order, this has been passed, resolved, sorry.
So what is that? So what are you saying? What's the role?
They're the police of the meeting, they keep order.
Yes.
The Speaker of the House.
That ain't a good example.
Okay, so the role of the chairman is to preserve order, to make sure that the proceedings are done properly. And also to ensure that the sense of the meeting is properly ascertained. You understand that last one? Sense. Don't forget now, you have an agenda. So they have that whatever's being submitted to that meeting makes sense. So they do preserve order, ensure the proceedings are conducted properly, which means that they have to know the articles inside and out, know what they can and cannot do, who can vote, when they should vote, when should notice be called, when the meeting should adjourn. Then they also have to know the Companies Act, the relevant section, and the first schedule for explanation. So, like Christina just said, it's something like the Speaker of the House. You have to know the rules.
Does he?
What's it mean?
Lisa said it.
Say
Lisa said
manager.
it.
Someone say speaking of the host.
Huh? Yeah, someone said Speaker of the House. Yeah.
That was me.
Oh, okay. Yeah, similar like the Speaker of the House. Just that he doesn't have a gravel. But always remember now, the chairman, he doesn't have any power to make decisions by himself. Decisions are made by the board.
But he has 2 votes.
Yes. So for next class, I want you to read the case. Buying, B-Y-N-G, B-Y-N-G versus London Life Association Limited. 1990, Chancery 170. This case discusses what happens when the meeting itself with the chairman and the other directors, if the meeting is not competent to act,
Is not what?
what should the chairman do?
If the meeting is what?
If the meeting is not competent to act, what should the chairman do? I want you to read that case because we're going to start next week with that case.
You say no midterm, right?
There's no midterm. No. Listen there. Oh, I hear that. You prefer to have a midterm? We could have one.
No, I just trying to figure out.
What?
Yes, how the summer you can be going.
How to what?
Like to summarize everything at the end of the week. Because this is a closed, right?
Of course the book will be closed.
Good try.
So we're gonna sit the exam in the classroom. We're gonna come in to take the exam.
Mr. Miguel will decide if it's in the classroom or online.
Okay.
Probably in the classroom.
Oh. Okay.
Oh,
You right until your fingers drop off.
You know, I got.
why are you saying that? You're panicking. Why are you panicking?
Oh, I'm kind of getting just.
Is there somewhere for me to sit the exam in, grandmama?
Oh, yes.
Me
that
too.
Arranged.
Okay.
Me too.
Yes, that can be arranged.
Let's actually, before we go, could you talk about the capstone?
Oh, yes. I did get an email saying they wanted to talk about the capstone. Where is it? Where did I put it? Oh, Lordy. Okay, start talking while I look for mine. Okay, I found it. Okay, go ahead.
Oh,
Let me
no,
hear.
I mean, the format. I remember you discussed earlier how you would want us to cite the case. You know, how to break it down. Is there like a word count or format or
No,
anything in
no
particular you're
word
looking
count.
for?
No, none of that.
Okay.
No word count, no format. None of that.
Okay.
If I wanted slides, I would have said slides. If I said presentation, then you'd have to do slides. No.
And it's 1, 2, and 3 or 1, 2, 4, 3?
No. And 1,
Just
2,
making
and
sure.
3.
Just making sure.
I should give you all a midterm paper to stimulate your brain. How that sounds.
A midterm paper, what that mean?
Magita,
Don't
what is
answer
what
them
is
What
wrong?
do
questions.
you mean?
Oh
You mean
Jesus! Look at listen to this. Even Cameron now gets something to say. Yes, how may I help you?
you
I'm
mean
turning.
like something to hand in?
Of course, and to be marked. I mean, we have the homework. I got 2 in, looking for the rest.
I'll say do it.
And then I'll send you a pre-incorporation. And like how we did the cases and went around the room. So you know you're getting something for homework and participation. So yeah. But if you want a midterm, I can give you one.
What is the name of the email with the caps on? I don't see it from you now.
Is it from me or did I send it from Miguel? Which one?
Did you
Normally I let Miguel send
you
the
resend it?
capstones. Yeah, he's on, so he can do it. You didn't
I
receive it?
can't see it. There's too much stuff in my inbox.
Okay, I'll tell him resend it. I'll
Okay.
tell him.
So,
I will tell him. So I'll send you all a pre-incorporation question. For those who didn't do, remember we agreed last class that you all would actually write out the answers for the questions last week. Recall.
Yes, I do.
Yeah, that isn't the one which you're referring to as the homework?
Yeah, I said I only got 2.
Okay.
I got 2 and a promise of 1.
Yeah, you getting mine.
So for homework, you're gonna read this case of Bing versus London, and you're gonna answer the question for me. What would the chairman do
What?
if the meeting is not competent to act?
So the last homework, that wasn't for discussion. That was something to turn in.
No, we had already discussed it. We had already discussed it in class, and then it was agreed that they wanted to see if they went home, wrote the answers out in full, if it would, like it was like a practice for them in terms of seeing for the final exam what I'm looking for. But we had already discussed all the answers in class. And so I
Right.
said, go home and write it out as if it was an exam question.
I have a question on this capstone. I think you were talking about 1, 2, and 3. What is 1? What is
Yeah.
1? I have 2 and 3, but I don't know a distinction from 1.
Okay, hold on, let me go back. What are you talking about? Because I didn't put the number 1. Number 1 starts from the role of different directors.
Oh,
And
and
it ends, yes,
at
and it ends at fraud. Yes. So right up to where you see the italics, Relandhurst Leasing PLC, that's your background work. Then comes the question. Discuss whether directors are liable in the below scenario.
And all left for the first one.
Yes. So you're going to read that scenario and you're going to answer that question and you're going to base it starting with these 3 cases.
Okay, so number 2 and number 3 are 2 totally different.
Yes.
Okay.
I bet.
So you're going to spend a lot of time doing number 1, 2, and 3 are fairly simple. So 2 and 3 should not be anything that is too long, but 1 will take you some time.
Ah, found it.
So anybody wants a midterm?
No, thanks.
You sure?
Positive.
If you do have a midterm, how would division of credit be? The point system.
Well, I'll stop giving you homework and just assign it to that.
Oh, how would the final be?
Still 50%?
Would the final still cover everything or just up until what we do for the midterm?
Up until.
From the point of the midterm to the last exam, that's all the final will be on.
Yes.
Oh,
That song is good.
that's interesting. Depend on
That
what
song
big,
is good.
where would you, when would you give us this midterm?
So the midterm will be open book then.
No.
It could be.
Midterm is never open book.
No,
I just was
I think
trying.
it should be.
I just was trying.
Hold on,
Okay,
let's
so
get
right
on it. Let's
now
get on
we're
it.
at, okay, hold on. Right now we're at 1, 2, 3, 4. We're at 5, right? Yeah, we're doing the fifth one. 1, 2, 3, 4, 5. So the midterm will end right here.
When would the midterm be? Not next week, eh?
No.
What would the
Next.
format be? Essay questions?
Short answers.
Okay.
Essay questions, yeah.
I have to agree on that.
I'm easy.
You could do it on March 2nd.
Oh, no.
2 weeks from today.
Yeah, man. You all have this?
I like these essay questions
Why?
because it's difficult to explain it. Like it's like when you know so much, you don't know how to put it in words.
That's the whole art
With that,
of midterm.
you have to know how to put it in your own words to show that you understand it.
You're right.
Yeah.
Break it down.
So just how you would understand it, like if you could explain it to yourself,
hmm
that's how you put it. If you can't explain it to yourself, then I mean, you know, you gotta still go back at it.
And go over it again and again and again. So you want your midterm as a take home?
That's a trick question.
What is that?
No, it's not.
What that
You
is?
could have midterm, it'll do you on the second. Look at the chapter that says company management. I think that is very short. Let's go to that chapter. Let me see if that one is the short one.
I
Dividends.
think this tonight was the
Oh
short.
no, company is that's long.
Company, that's chapter 7, company management.
Yeah, that long. That's the one we talk about shadow directors. Hold on, which one you said? 9?
Oh, 7, sorry.
No, it's 9. It's 9. That's the one I was talking about. We can skip 9. Company compliance, we can skip 9 because it's very close to what we just did in record keeping. So, company compliance is on March 23rd.
Which one?
That'll be company compliance, March 23rd. Look on your schedule. So you can read this, right? And your midterm will be due that date.
On the 23rd?
Mm-hmm.
And it'll be on company compliance. Or
No,
everything. Oh,
chapters 1 to 5.
okay.
I think I'm a little confused on what you're saying now.
We can do a midterm take home.
So you will send the questions.
Yes,
Okay.
And it'll be due on the 23rd?
it's due on the 23rd. Now let's decide when I'm sending it to you.
No, hold on, I can't, I know I can't
It's
do that
due on
one.
the 23rd of, yeah, it's due on the 23rd of,
March.
March.
yeah, I can work.
What you mean the 23rd of
No,
February?
Yes.
you're not looking at the
Yes.
schedule. Look at the schedule. Company compliance is March 23rd. You have your schedule out?
I look at.
So March, right, March 23rd, it says company compliance. You will read that on your own. On that night, your midterm will be due. So why has this big gap between 9 and the 23rd? That's not Easter. What happened to the 16th? Why is the 16th missing? Miguel, okay, well, okay. If the 16th is missing, then let me send you the question on the 14th. How that sound?
To be due the 23rd.
Yes. So you look like you have a break. Do you want that break? Or you want me to change this date from the 23rd to the 16th? Where you'll have more time to the end to study for the final and prepare your capstone.
I think that's a better option.
Feeling lost?
Why
So
you
the first,
take your
so
take your thing out?
you'll send it on the 14th of March to be due
Hold
on the
on,
6th.
hold on. We're gonna do this now.
She have to change the sending date, the sending.
Right. So we have February 23rd coming up, March 2nd, March 9th, and then he has the 23rd. Change the 23rd to the 16th. Change the 30th to the 23rd.
Change what to the 23rd?
The 30th.
Everything will stop on the 23rd.
Yes, because he missed a week. So your midterm will now be due on the 16th.
And the midterm is what now?
Chapters 1 through 5.
That you would give us a question on.
No, one question. You have more than one question.
I mean, that's what you'll give us.
Yeah.
And then the final will be based on everything except chapter 9, because chapter 9 is basically covered
Right.
today.
So the final exam will be on February 23rd. The shares and shareholders. It will be on managing risk, and it'll be on company liquidation.
Say that again, please.
The final exam will be on shares, shareholders, and capitalization, company management, managing risk, and liquidation. 4 topics.
For the midterm, we come in to do an exam as well.
For the midterm, no, midterm is going to be a take home.
All right,
The
so let
final,
me, I understand.
okay, go ahead.
If we do a midterm, it'll be on March the 16th, which would be covering units 1 to 5. And these are questions that you're going to give us to do at home.
Yes.
the final exam would be now on still April 10th?
Still April 10th, I didn't change that. You want to
Okay, so
change
still
that?
April 10. No. Still April 10.
You have it on the 6th?
I can't have it on the
It's
6th.
fine, April 10th.
Okay.
Yeah,
April 10th is
I
April
fine?
used to
6th is
wait
the
around
day
this-
after Easter. Mhm.
Yeah, that's Easter time.
Easter Monday is
This
that
Monday,
Monday.
I'm off again.
Yeah, that's my birthday.
Easter Monday is
so-
April the 5th.
Yeah.
Yeah.
Right.
Still April 10, company management. I just want to name them off again because my dog is barking. And you,
Okay.
yeah,
What's on the final exam?
yeah. Like what
Um,
it be?
February 23rd, shares and shareholders. March 2nd, company management. March 9th, managing risk. And March 23rd, company liquidation.
And then will we meet on the 30th for review?
I normally do the same time as company liquidation.
And can we meet on the 30th for review if we choose to?
Up to you, but I mean, we only be covering 1, 2, 3, 4 chapters. So most likely your exam will only have 4 questions on those topics.
One
That's
page
it.
each.
Yeah, most 1 to 2,
So just
depends on
broken
what I
down
write.
to like 25 points each.
Yes, or 20 points.
They heavy
Mhm.
questions, 25 points each.
You
Of
still
course
doing
they
little
are.
multiple and the short answers, the whole variety, or this strictly now essays?
Well, do you wish to have them?
I want a mixture.
That's 2 people saying, yeah.
Yes.
I agree as well.
Say what?
I agree with the mixture too.
Okay, finals. Mixture. You want the same thing for the midterm?
That'll work.
Yeah, I think that's a good style to have.
This out now. You sound,
Say what?
you sounding too happy.
Yeah, I give you what you asked for.
Man.
This only this can be difficult.
Yeah.
Don't mind. So we all on the same page, right?
Yes.
Is on the 10th. You didn't touch that date.
Right.
So you just move those 2 dates there. So now let me see when I'm going to send it to you. Okay, March 16th. We have class on the 9th. You need a week or you need 2 weeks? I think you only need a week.
What? Sound like 2 capstones in one.
You need a week?
3 of the final.
Because it's due a week before, well, plenty time before the finals, man. You have to study for the finals. Let me see how many weeks you get. 1, 2 weeks.
Plus the capstone, right?
Yeah, but you have the capstone now.
But we don't have to finish everything before we go through that?
What do you mean? The capstone is due on the day of the final exam.
But I mean, in order to answer the capstone, we have to complete everything first, no?
I can't tell you that. You got to read the questions to see where they're coming from. Okay, so should I send you this midterm on the 7th of March?
You can send it tomorrow as early as possible.
No, it's too early. You're going a whole month?
Send it on the 1st. Because you say it on the 9th, right? It's due the 9th?
No,
the
it's due on the
16th.
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 16th. Sorry, my bad. I supposed to say 16th. But yeah, the first.
If you don't get these dates right, it'll be me and you.
I write them now.
So
This
you
is
send it on
the first.
You send it 7 like in the daytime?
You send it by midnight.
Yeah, send it tomorrow though.
So you can't send
No,
it
it's too early. On the 16th, you have to send it to me by midnight. It's due on the 16th. So cutoff time is midnight,
Okay.
right? So I'm going to send it to you on the 7th.
On the 1st.
No, you don't need 2 weeks.
Okay, sorry, my bad.
Now give me a phone
That's
call.
total.
7, like what, Saturday midnight?
That's what I'm saying. Like, or
Work is be long,
mid-
man.
or 7 midnight on Sunday.
Okay, 7. What you talking about? When you send it to me?
No, you sent it to us like early on the 7th or late on the 7th.
It depends. What you prefer?
The 6th.
No, we talk about the
So I
7th.
know we can get it by the 7th. You might come 11:55 in the night and say it was the 7th.
I want you to enjoy your Saturday and enjoy your Sabbath. 5 o'clock? 3 o'clock?
3
See, I
on
don't want to
Saturday,
interrupt
7.
your family time because when you see that pop in and
Ain't
you
no
know
time
you're
for
expecting at
family.
a time, you will be saying, oh my God, it's here. Okay,
Well-
send when? What time? Send March the 7th
When you wake up,
at, you sure?
all you gotta do is press send.
Ah, so nobody's going to church on March the 7th.
That don't matter, is you still gotta condition your mind, you know.
You may have to sit down, depending on how does it.
12 noon. 12 noon. I'm gonna send it at 12. You happy?
Easier, eat something me.
12 noon. Eat your breakfast or go to church, do whatever you're gonna do. And at 12 noon, it'll be
I'll
there.
pray for him to guide you, huh? When I go
What that
to
means?
church that morning, that I don't
Oh.
have hurt feelings when I get this test.
Well, don't forget now, I won't just be writing it then. It would be written.
So,
Yes.
yeah, you said it was no marking, no.
No.
Okay.
You did some questions. That's the ones where you sent in 2. When I only got 2 responses.
What are we getting anyone now?
Okay, so. So your midterm. Okay.
So for our midterm, we're going to be covering.
1 through 5. You wish for it to be less? And put 1 or 2 the final.
General company laws, types of companies, client due diligence, company incorporation, and corporate record keeping.
Yes.
Which, okay.
We're all on one boat. Cameron, are you with us?
And more than likely, we'll be getting like cases to answer then.
Oh yeah, you have to know the cases to go with it.
Okay.
Depends on the question that I ask. You have to support it with cases. It's open book, it's take home. So you should be able to look up to support your answers.
I'm thinking, okay, all right.
Yeah, it's only the finals when you really need to know your cases out of your head.
Okay. So this one would actually just be us answering properly with substance.
Yes.
Okay.
And so when you write your final, you should be able to write even better.
Okay.
And because it'll be typewritten, I guess most of you will type it out. I can mark it faster. Versus handwritten, it takes longer. Because I have to decipher I have to decipher what you're saying.
Okay.
Okay, I'm putting in my diary when to write the midterm exam. It's diarized. Chapters 1 through 5. It's done. sent on the 7th of March and is due on the 16th at midnight. Okay, it's all done. Everybody happy now? Oh God, who isn't? It's a giveaway. Who's saying not really? 7, 8. Everybody's happy?
I have a question on, well, it isn't about the capstone, it was about the homework that was due. I just wanted to understand one of the questions. It said, can the registrar refuse to register?
Mm-hmm.
I don't know why, I didn't understand that. What do you mean?
The Registrar General. Can they refuse to register a company?
Yes, eh?
That's what the name.
We discussed this.
Like in reference to, right, the name, like if it's incorrect, like I didn't understand, like from what context?
Or any contact.
Any context.
I would
Can do
think
they have the right?
to register, to refuse it in general. Well, I would assume that they could, but I couldn't find it to support my answer.
So it sounds like you need to do some
The
more
name,
digging.
And I read and
the
I
name is,
read. So hopefully you could, when you check that, send it back and tell me where it is.
Okay, like I said, I got 2, and if I get any more, between now and what the day is? Tuesday? So between now and by Saturday or so, then I'm gonna mark what I have.
Okay, I'm gonna send mine.
The ones that you would have received, you would have sent an email to say received, or?
No, I receive it.
Okay.
The email couldn't be wrong. We already been
Okay, because I know
exchanging emails for a while, but I only got 2.
Okay.
why am my brain gonna bleed out by this week?
Okay, so that's what I'll work with. I'll work with those. Okay, I have what I gave you all. And so I will go through those. Okay, everybody's happy. Wonderful. I'll see you all next week, where we're going to talk about some shares and altering capital. So everyone should be happy. Yes?
So you say,
Oh, God, it's just killing me, man.
Natasha,
Yes, Makita?
you want the homework by the Saturday?
Yeah, I want it by Saturday. Because I want to mark them and send them back. Now, let me warn you now. When I mark, if you start off and you start off wrong, I stop marking.
But I ended it right.
No. That's guessing. That's guessing.
They come correct one time.
Yeah, you got to come straight. Now, if you start off right, then you may sway a little bit and come back. I'll eat it. But if you start off wrong, you like, okay, let's say the question is on pre-incorporation, and you start talking about something totally different. You may have, like, some students just come and argue and say, but I talk about pre-incorporations down on page 2. Well, the question was only on pre-incorporation. What is all of this? What is all? No, that's just like trying to in the weed and trying to find a flower.
That's the fluff.
Yeah, no, I don't like fluff. Get to the point. Get to the point. So no fluff.
Okay, noted.
Okay. Make sure, don't come with all the fluff. If you don't know the answer, you don't know the answer. Guests don't leave, especially for the final exam. Do not leave a question blank. So you better go in your memory banks and figure out what you could write. Because you realize that if you don't answer one question, you've already lost 20 or 25 points.
You might as well write fluff stuff in there then.
Well, try to write something, make it your last question. Don't make it
Yeah,
first
but
one.
that's fluff right there.
But I'm saying, make it your last question. So if I'm looking, this is your last question. In my mind, I'll be saying, this person ran out of time, looking at the writing. I'll take a chance and read it. But if I'm starting writing your paper and your first answer is fluff, well, what could be for the rest?
Fluff for fluff.
Oh, okay. So let's start off. If you know you don't know the answer to that one, don't make that one your voice. Stop it. What you know, so I can see you going down. Rather than go down and start to go up. All right. So the whole point of doing this midterm now is to see if you understand, if you are able to put it on paper, and is really articulate. And I see that you know how to apply the cases in law, or you know where to look in the Companies Act or the IBC Act for your support. So I'll try not to make the questions too long, because I really want to see how you apply it. So everybody should be happy. Happy, happy, happy. Yes. Silence gives consent. Shaquille, are you happy? I hear enough. You said yes? I guess she is. All right. So next week it is. We'll begin another interesting topic. We're going to be talking about shares and shareholders and capitalization. I may present this one a little bit different, so I need you to read the chapter. I'm going to try to make this chapter as practical as can be. So we're not going to be going over definition. So please take the time on Sunday to read the chapter. Okay?
Okay.
All right.
Oh, Lord.
Huh?
Nothing. I can't pray for myself.
Why?
I have a midterm on Monday. I'm just gonna figure this out.
Oh God. Just don't get your date mixed up and call me later, ask me which date go with what.
No, Saturday for the homework last week, right?
Yes.
And then
March.
March. Yeah. Mhm.
Okay, we're good. Okay. I'm good. Any more questions?
And the case you said to look over the Bing versus London Life. That's for to go with the shares and shareholders and capitalization.
No, that'll be the wrap up what we were just talking about. Yeah, that's about the chairman, what the chairman should do.
But I mean, that's homework to hand in for
That's
Saturday.
homework. Yes, if you have it finished.
Okay.
Everybody is happy. Okay, let me get this. No. And then since we've decided on the midterm, we may have cases to read over, but there'll be no more homework unless you wish to have homework.
Okay.
You can let me know next week if you wish to continue having homework.
So Ms. Archer, so we only have to hand in those two stuff.
Yes.
All right.
So those who submitted their answers already for last week. I don't know if you want to review it again or you want me to look at it as it is.
I'll review mine. I'll send it in again.
Okay.
No, what you could do is review mine, and then you tell me what you need me to change.
That's what you want me to do?
Yeah, don't grade it. Just review it and tell me what you want me to change.
No. Have a look and see if you want to make any changes to it.
Okay.
So I'll discard them, and then whatever you all send in, when I open up on Saturday at 12 noon, I will mark those, what I have.
Okay.
And then we'll go from there. And then when you get it back, you'll see what I'm looking for.
Okay, that's fine.
Okay, all right, so we good. We're good. All right. So that's it. If any other questions, you could always send me an email, but don't ask me anything about the capstone. Did you hear me?
Yeah.
Yes.
I didn't hear a word when I said that.
Suppose you need clarity on something.
That's fine.
Okay.
You don't need any clarity, so no. You haven't even read it yet, so you don't need no clarity.
Hey, look at that nigga, Cherry.
Oh God. You won't. It's
And so
all
just
your brain.
it's actually for clarity. So for the Bing case, you wanted to know what would the chairman do if the meeting wasn't what competent to act?
Yes. That case explains what the chairman will do.
Or if the meeting wasn't competent to act.
Yes.
Oh, wasn't.
Yeah. I want you to get this part down, Pac, because I could question, and you're gonna have to know what happened when the shareholders or the members aren't able to make a decision, or the directors aren't able to make a decision. What happens? Last class, we did the shareholders. This one, we're doing the directors.
You say when they can't,
But
you say when they can't make a decision.
Mm-hmm.
Okay.
So you can see there's not much time. So you really need to get started on your capstone to start pulling your cases, reading it, understanding it, and then look at the scenario and come up with an answer.
Sorry, what's the question for the BYMG versus London? You said what the chairman would do?
Mm-hmm. What would the chairman do?
Okay.
When he acted in that case.
And this one is due for next class.
You're gonna send that to me by Saturday,
Oh, this one too. Okay, okay,
if you wish.
okay.
It's always up to you if you wish. Four. All right, I think I have everything down, packed and ready for you all to go. Okay, everybody's clear?
Yes.
Which for the questions from last week, it would be good if you make an attempt. So you'll know when you answer your midterm questions. You stand a good chance of knowing what I'm looking for.